like our very first method.
There's some very aggressive people you're throwing.
And I was like, must be easy.
That'll be
And then it said,
AirPods for the room. Is that your singing everything?
She does
you're not the reason I wanted to car.
You covered it there.
Good AirPods too.
So like kind of reduces the go a little bit, like acknowledging the difference.
I know you do. Did you listen to music? I started talking before.
I knew that was I started.
It's a great way to get more people.
Like I started or like when I started and like you see everyone wearing stiffest dress and like I went there and then like I live in Utah nowhere.
Oh, why in your car? Because they have those wireless chargers in the
Well, they're
console
changing the
now.
tax code is not helpful because fewer people are going to be able to.
When you get a new car, whatever you get,
I know, right?
you just keep going.
Literally anything that I get.
I mean, you can give stuff away to the eyes.
Hello, how are you?
But now,
20 years old. Something in the
But they just started.
So it only works on
T-shirts, I mean,
Don't look it up someplace.
Yeah, I'm sure there's some intelligence for that. I got one, so maybe.
Like,
I just sat there for like 20 minutes. I know, right? Well, it works on other phones, but if you have an iPhone,
Okay, welcome everybody. Welcome everybody, and I'm delighted to, without tripping over things, welcome our guest today, who is Ann Armstrong. She both has a degree in nursing and a JD, and she is senior counsel at this point at Intermountain Healthcare. She's going to talk to us, with us, about a topic that's of great interest in contemporary healthcare, that of communication and resolution in situations in which perhaps there was a medical error or at least an adverse outcome. And she's also open to talk about what's it like to be in a general counsel's office in a major nonprofit healthcare company. So without anything more, I'm going to give you Ann Armstrong.
Thank you, Leslie. I'm really happy to be here. Thank you for inviting me. I'm just going to tell you a little bit about me. I guess this isn't working, but I can press the button.
That's
I'm not that high maintenance. But yes, as Leslie mentioned, I'm a licensed registered nurse actually in the state of New York from a long time ago. So I describe my sort of career into 3 big blocks. So went right into nursing school, nursed for about 10 years, started having kids, stay-at-home mom for about 10 years. Rather than go back into nursing, decided I would go into law school, and I've been a lawyer since 2000. And I've worked in a couple of firms in Salt Lake. When I first finished school, I went into insurance defense, medical malpractice defense. We did a little bit of regulatory and licensing issues for healthcare providers and systems. And then I joined Intermountain just about 8 years ago, 2010, 9 years ago almost now. So that's me. I'm happy to talk about any of those topics, but I really want to focus today on something that Intermountain, Intermountain is embracing. It's very much a work in progress, and it's a learn as you go kind of endeavor, but it's gotten a lot of attention in the healthcare community, and I think some also in the legal community, It's basically, and I struggled with what to title the presentation other than it's commonly called communication and resolution is a very common way to describe these programs. But when I try to think about what does it mean to me as an attorney, because we do have a role, and I think a fairly important role, it's really the strategy of managing the claim and the patient's demands and their claim and allegations in a way that supports the overall mission of a just and prompt address of their self as a person. They've been injured, or they believe they've been injured. And the system wants to address that in a very fair, just, and quick way and answer questions. But there's always the option of going the litigation route. So this is just an overview of what the slides are going to talk about. I don't think we can start without covering a little bit about what we refer to now as the patient safety movement, and then generally a little bit about the the early development of communication and resolution programs and how they tie in with professional liability, and then the legal issues that we continue to struggle with and confront as we try to implement our program. So, of course, patient safety isn't a new thing, right? I mean, this is a really common phrase, do no harm, and it's not technically part of the Hippocratic Oath, but it's associated with becoming a doctor, and it's a very important motto in medicine, do no harm. So, obviously, patient safety isn't a new concept, but there really is a very recent sort of focus on patient safety in a different way than the past, and that began in 1999 with this report, which was published by the Institute of Medicine and a specific committee within the Institute of Medicine on healthcare quality. And the name is very telling, but it's the To Err is Human report. And some of the findings, I mean, it was a pretty extensive report with recommendations. Many of you may have read it. And they do go into a lot of depth on whys and that kind of thing. But some of the things that really jump out are the numbers. So 44,000 to 98,000 deaths per year due to medical error. And this is only deaths. This is only hospitals. So this did not include numbers for clinics, home health care errors, ambulatory surgical centers. This was only hospitals, and some estimates are that about half of these were deemed preventable errors. Some estimates that number is a little higher. And the authors of the report calculated that the death rate from medical errors exceeded motor vehicle accidents, breast cancer, and AIDS. And the cost of the errors was, this is one estimate, I've seen 50 billion also in the literature, but many billions of dollars. So, as you can imagine, this was a little bit startling, not only to the public, but really to the medical community when this report issued. So if you think about it, that death toll is equivalent to a commercial airliner crashing every day. So it calculates down to 120 to 268 deaths per day, that number on the earlier screen. And then injuries were calculated at over 1 million per year due to medical error. So kind of a disturbing and startling revelation. That was not, until this report, I mean, if it was an airline accident, there'd be a lot of attention around that. There'd be news coverage and breaking news, even when breaking news wasn't like, every time someone had certain food for breakfast, but it really was, something that was alarming and the public really wanted to focus on it. But there wasn't that focus. And so why? So some of the reasons for the quietness with which all of this was happening in our country and in our hospitals were connected to the way, as defense attorneys and as hospitals and as providers, we reacted to those events. So they were handled relatively quietly. They were handled as one-off circumstances, dealing, the patient was dealt with. A lot of times there was nothing done or reported or discussed unless a patient brought a lawsuit. So some people hedged their bet that, yes, they were aware that something had gone wrong and that a patient had been harmed, but maybe they'll never get sued. Maybe if we're just quiet, they'll never do anything about it. So, and then the ones where people did bring it up and people brought a claim, they're also handled almost what's been described as a little bit secretively. And that's not necessarily all bad. I mean, these are usually claims in dispute. I mean, a lot of times it's not totally clear that there was a medical error. There are complications that can occur with any medical intervention, and it's not always that somebody did something wrong or made a mistake or there was an error. There can be a really disappointing and bad outcome that isn't anybody's fault. So protecting the people involved in those types of claims is important. There's a lot of personal feelings about this on the part of the caregivers when they're named in a claim that they've done something wrong that's injured someone. A lot of the caregivers we support and that I've supported, both at the firm and in-house, are very cautious about who we talk to. We get, who can I talk to in your office about this? No one. Just call me directly. I don't want anyone to know. So people have individual ways of wanting to deal with this kind of situation, which contributed, I think, to the fact that this was kind of under the radar and wasn't looked at as a health problem. And we didn't have statistics like how it compared to other types of illnesses or conditions. And this is the full title of the report, Building a Safer Healthcare System. So some of their conclusions were that as an industry, healthcare is years behind other accident-prone industries. So healthcare was identified as a very accident-prone industry for a couple of reasons, and those of you with backgrounds in like systems management probably understand this a lot better than I do, but healthcare is complex, and each decision kind of is hinged to another, so it's all connected, and there are time constraints and high pressures, and all of that leads to it being accident prone. But so is flying an airplane, so is nuclear power plants, but they have a much better safety record if you looked at it that way than healthcare did, which is what led to really decades, or at least a decade behind is how it's been described. And then there was faulty perceptions about the cause of medical errors. And that kind of takes us to the third bullet where we're going to focus a little bit more intensely. So faulty perceptions about the cause of medical errors is referring to, I mean, the cliche saying is blame, shame, train. So you figure out who's at fault, and it usually came down to an individual. So that's the blame. And then you focus on that person, which creates a feeling of shame, but you focus on them maybe kindly, maybe in a disciplinary way that doesn't feel so kind, but even if kindly, and retrain them. So the problem here is that the nurse didn't understand the procedure and gave the wrong medication, and the patient ended up being harmed. So the problem is really this nurse and decisions the nurse made. And this report concluded and actually realized that this was a very faulty way to look at the problem, because what you need to understand is why. What about the processes and the system and the resources available to that nurse led that nurse to make that decision in that moment? And if we don't focus on that, and if we take 200 plus a day and we fix each nurse, each lab tech, each doctor one at a time, it won't fix the real problem, and so our numbers are not going to get better. We're not going to have overall improvement of patient safety. And part of this way to look at cases really is this faulty way is really reflected in the way institutions and insurers and attorneys handle medical errors, including the way they manage the negligence claims that sometimes follow. So what would be the first thing we used to do? Set someone up with an outside attorney, hire an attorney, and they feel so much better, we thought, right? Let's get you an attorney. They'll tell you what you can say and what you shouldn't say. They'll look out for you, they'll protect you, and we'll have less discoverable information out there, and we'll all be better off in the long run. But it doesn't really lend itself to really exploring, well, what happened? What are all the factors? What are the system factors that came into play? What are the human factors that came into play? What really caused this problem? And can we fix those things and avoid further injury to our patients? And so one of the things, so I start with the overall, the patient safety movement and to err is human, because it is sort of what drove this new way of thinking and looking at things. And part of what evolved is, well, why don't we just really be honest with ourselves and be honest with our patients, and let's tell the patient what happened, and let's see what we can learn from the circumstance, and let's focus on making ourselves better. And so it's a little bit of a different view, even from the claims management, and this different. So in a communication and resolution program, the emphasis is not on self-protection, and we actually look for that, and when we're developing processes and when we're going through sort of what we call a pre-disclosure review before we sit down with the patient. We look for indications that we are being self-protective, which is kind of comes naturally after you've been doing this for a little while, and you have to guard against it. So some of the acronyms and titles of these programs, and there's a variety, like they're just sort of organically developing in different systems and in different places around the country, but these are common things you'll see: Communication and Resolution Program, Early Communication and Resolution, and CANDOR, which is really an actual set of tools and materials and a program that you can access through the Agency for Healthcare Research and Quality. And that is related to a grant, and some tools were developed, and you can get on that website and review all their tools. And their system has some specifics to it, which we are modeling ours after, but not precisely. So we deviate a little bit from their precise protocol, but find a lot of their tools and toolkits and methods and guidelines super helpful. And then some of the systems that are pretty far down the road and have been doing this for a while are listed here. I'm sure there are others. And we embarked on this just about a year ago. It came at a time when Intermountain was going through a pretty expansive corporate restructure, and with some new leadership that came in. And I think, and it's very exciting. It's a change in mindset, but we have a lot of really strong leadership support, which I think is critical, and you'll see that in some of the literature that's one of the critical components to a successful program is really at the very top, leadership support. And our program has a physician who is directing it and overseeing it, who's also a leader in the organization. And that helps too, to have a physician leadership and not a purely business leader, like an administrator. But the reason these are different, so this patient, the goal is to, at the time, as soon as you realize that there's an event, so before that happens, you need people in your system being very comfortable telling you something went wrong. So you need a reporting system. You need a way for people to trigger the program, to say this bad outcome happened or this error was made, either on behalf of themselves or on behalf of their team or on behalf of something they saw. So to get the information into the system where everything then is, follows a workflow, obviously, in a process, but people are assigned to review those reports depending on where they occurred in our system. So even before you can start, you need that confidence and that comfort level and that trust on the part of your healthcare workers, which we call caregivers, and providers and physicians, just basically everybody, administrators, everybody, to feel like the process is the right way to go and to be comfortable reporting. But as soon as you know that there's been an unexpected outcome or a complication of some kind or a patient injury of some kind, that needs to get investigated very quickly. And so what CANDOR recommends is that you have a couple of teams. One will go directly to the patient's family, and they provide support and they gather information from their perspective of what happened. Another team will go to support the providers, again, to support them as caregivers, because this can be very traumatic for some of them, and to gather information about their perspective about what happens. And then you have a third team that those two teams funnel information to that does a comprehensive investigation. So when you first approach a patient, you express, expressions of sympathy. You apologize. You tell them you're going to look into it. You're going to do an investigation. You're going to find out what happened, and you'll keep them updated as the process continues. And the idea is to do that right away. Because what happens if you wait until you have to go track down the doctor to find out why you're having all these strange symptoms ever since your surgery is you're in a different place. You are the feedback we get directly and the feedback the research you'll read, the studies you'll read, support, the same thing we're seeing is patients get wary. They feel like, why isn't anyone talking to me? Why do I feel like when I try to bring it up, there's this veil of silence, or they're protecting each other? What are they hiding? And then sometimes what they imagine is even worse than what really happened, even though what really happened could have been really bad. But it becomes worse and it becomes bigger, and then it gets harder and harder to work with them to get their help in fixing the problem, to get their honest feedback about their perceptions, what they think happened, what they heard, what they saw, what they believed was going on. And we're more in a very, adversarial situation. So the common characteristics of these programs include immediate identification of an adverse event, a rapid response, as I just described, far more rapid than the old way would get you there. It could be weeks, months, years before we looked into things in the old way. Maybe if we just ignored it, we never would have to. It was kind of an approach that some people took. But I'm talking within 24 hours at the bedside to the patient, quicker if possible. Very rapid meeting with the patient. And then an investigation and analysis, which we want to be quick, but we want it to be accurate and thorough and carefully done. So I think we're looking at 30 days to get a complete investigation. Sometimes it can be done much quicker. But the investigation will not just focus like we used to on, okay, somebody messed up here, who did, and what's their problem? Do they need some training? Were they distracted? Were they having some personal issue? What's the issue with this person? It really requires looking at system factors that contributed to the outcome, to the sequence of events, and the human factors. And then there's a disclosure, and that's where a lot of the legal questions come in, as we'll look at in future slides, and as you know, our statute and our rules of evidence and our case law, I think will show is that there's a little bit of a difference in what you can do in the rapid response versus what you can do in the disclosure if you want to avoid admissibility. And that's how I sort of come to look at it. And then it goes into a resolution mode and system improvements, which are basically two separate activities arising out of the same learning, right? So you want system learning to occur, and you also want to make things right with the patient. So we call the making things right with the patient, the compensation piece, or whatever it is they need to heal, the resolution. And then system learning needs to take place. So improvements in the system factors and in the human factors can make it less likely to occur in the future. And then the system has to be just when it comes to the individuals involved. So they really break that down into sort of three types of problems with an individual. There's just a lapse, a misstep. So think of it like you drive the same route home every day, and today you're on the phone or you're listening to something on the radio and you drive right past your exit. Just no way to predict that your mind is going to make a slip like that. But you know what to do. You know you're supposed to take that exit. You don't need to be retrained or re-educated. And then there's the retraining. Well, I didn't know. I didn't have directions. I didn't read the procedure. I didn't know there was a procedure. And so that's the next level. And then the third level is just a reckless disregard kind of standard. So, yeah, I know, but I figured, what are the chances? And this was easier for me. So those people get disciplined and perhaps terminated. But the other people get supported, and they're worked with, and they contribute, and they have input into how do we avoid this from happening. Those kinds of errors. And this is our workflow, which very closely follows the materials you'll see on the AHRQ website. But it basically goes through the steps and that we've already just talked about. So identification of an event, the early disclosure and activate these teams and start the investigation process. And then there's a period of time where there's exchange of information because it's really hard to do. You can look at medical records and sort of piece together what you think happened, but without input from the caregivers involved and the patient, it's harder to get that really right. And then we go to system learning, which isn't the lawyers. We support some of these processes. They may have questions that they want to talk about in a protected setting. We can help with that. We don't usually help with system learning other than sometimes system learning is issuing a big newsletter that's broadly disseminated through the organization, right? Like it happened here kind of thing, where the circumstances are described. And they have to be described in enough detail that that's a meaningful tool for improvement. But then we get to review it, and we can take out things that are maybe a little bit inflammatory, things that might be overstating, like everybody felt pressured. Chances are everybody involved didn't, but we get that there was a sense of, time constraints and pressure to get the patient through the OR or something like that. But that's a back and forth between us and the patient safety team. And we say, well, this is what we see, but we don't want to strip it of its usefulness. We want it to accomplish what you want it to accomplish. So we're very willing to compromise and not be sort of the rigid. So if you go to outside counsel, they'd be like, what are you doing? Are you crazy? No, don't do this. Never, never, never. And we hear that. We're like, well, we are doing it and it's important. So we don't have the same, I don't know how to describe it, but I understand that especially for outside attorneys, and we feel it too in-house to some degree. You know, you have this sense that they need to know what they're doing, so you need to warn them enough. You need to have enough caution around what you're saying so they get that they're taking a risk and what the risk might be. But we always complement that with how can we mitigate some of these risks and bring that down to a tolerable level. And it can't be done without any risk, and we accept that. And it's a little easier for us in-house for some reason than it is for some of our wonderful outside attorneys who we couldn't live without. But they have a little harder time with some of these approaches we're taking. And then, you know, we read them sometimes and we know who they're talking about because we're dealing with a claim. We have a claim from this person. The patient safety team might not realize that we've already gotten a claim. They just want to get this word out there that this happened, and here's how maybe if this is going to happen in your OR, here's how maybe you can avoid it. Here's some things you want to look at and talk about as a team. I mean, we have 22 hospitals, so something could happen in one hospital that could just as easily happen tomorrow in another hospital across the state. And the patient safety team wants people to pay attention to these things and to think about them and to talk about them and to develop their own sort of improvement measures. So sometimes we read them and we know exactly who they're talking about, and sometimes we can make it a little more generic so it's not quite as easy to identify exactly which patient. So we do things like, do you really need to know which hospital? Do you need to know what precise procedure was being done? Do you really need to know the age and gender of this patient? Probably not, to get your message out. So let's see what we can do to get the learning value from it without providing so much information that we feel like we're really exposed. And then sometimes it comes down to it's worth it to take the risk. But everybody, you know, our job then is to make sure the people making those decisions, the leaders in the organization making that decision, understand what those risks are and is willing to accept those risks. And frequently they are, and it's kind of fun and exciting. And then we spend a lot of time as attorneys in the disclosure and resolution piece, and we've spent the last year just building workflows to get this running smoothly. So we're now just starting to, and we've done a lot of resolution. The disclosure piece is where I love feedback and help, because that's a tricky one for us. The resolution isn't so hard. It's just a negotiation usually, and sometimes we have to step in and say, well, yes, that happened, and we're very sorry, and we realize that this has had an impact on you, and we appreciate your forthcomingness, and we appreciate your courage and your sharing with us. But we really don't believe that the headaches that you've had for the last 25 years are related to this thing that happened last month. So we feel like a fair compensation probably is going to exclude that. And it is pretty much in that gentle of a way. And we usually get a pretty good response, like, okay, yeah. Not always. Sometimes it's like, no, I want the moon. I'm obviously worth $50 million, ask anyone, and that's what I think I'm going to get. And we might end up litigating damages and admitting liability. But usually we can work out what is fair and reasonable. And we really, I think it comes across that we truly aren't trying to nickel and dime, and we're not looking for ways to chip at the value. We really evaluate, is this fair? Does this make sense? And there's frequently no way to prove, right? If we missed a diagnosis, say a diagnosis of cancer for 8 months, it's hard to know what that outcome, how that impacted the patient's outcome. I mean, we have experts that can help us get close to understanding that, but we can't always completely understand that. And a lot of injuries are like that, particularly errors of omission. A lot of times it's hard to know how would this patient have fared, what conditions would they have been left with, how severe would their condition be if it wasn't for this thing that happened during the course of their illness, because we usually don't give them the condition. They usually have something, which is why they're in the health system. So resolution is comfortable for us. We're used to claim management, we're used to negotiating, we're used to resolving claims, we're used to litigating. Disclosures, a little scarier. And then this is just another slide that we've shown. Oh, it has our a citation. So we've done a presentation, myself and some of the patient safety team, to our physicians. And this was a slide that was included, and I just borrowed it from that presentation. But these are some of the differences between the old way and a communication resolution program. The patient is extremely involved. They're kept updated. They have very many opportunities for input and to describe what they experience and what they want to see happen. So a lot of our patients want changes, and they want specific changes, and we take that very seriously, and we work with them on how we can make the system safer. And it's a very transparent process and ongoing updates, as I said. And the transparency also makes some of our great defense attorneys really uncomfortable. But I've been to a couple of disclosures to observe, and it's transparent in a way that is a little unnerving. So we did one in the middle of a case. So it had been in litigation for years, but we looked back at some of our cases with this goal. Let's look at this case we've been litigating for 3 years and decide if this happened today, would we route it to this process and try to resolve, or would we defend? And most of the time, we defend, because Intermountain has a history of wanting to resolve early when that seems appropriate. Not as often as we will be doing now with our new program, but we were fairly good about being honest about that with ourselves. But this case had been really intensely defended, and the decision was, we shouldn't be defending this care. We should be disclosing what happened. So that was scary, right? In the middle of, expert discovery was done, and we sat down, plaintiff's attorney was present with eyes this big through the entire thing, and mine were probably just as big. And at the end, just riveted on these wonderful people who very gently explained to this family what had happened to their loved one. And at the end, plaintiff's attorney said, I didn't know some of this stuff. He thought he would hear what he already knew, what he had in his allegations, what had been explored in depositions, what his experts had criticized in their depositions. And he said, you told me stuff I didn't know, and you didn't have to tell me. And he was pretty floored. And we got that resolved. Fortunately, we got that case resolved, and it was a very healing experience. It was very emotional. There's a real connection with people when you stop fighting and you just listen and you share what you can, and your goal is to help them heal, because the litigation process itself is very hurtful for everybody involved usually. And the goal is really to improve care and address the wrongs and the injury and the hurt, both physical and emotional, that we've caused. I think I covered most of these. And then I do want to put up a slide that was also in this presentation. And this, I don't think the quote goes with the picture, but I think both the picture and the quote covered the same topic. So this is a quote from an ER doctor, and this is obviously a picture of a doctor who needed to step outside for a few minutes. But I'll give you a minute to read it, but it's in here because we want the doctors who have to accept this, what we're asking them. It's hard to accept, right? They feel exposed. They feel like, well, what are you going to tell them? We invite the doctors to the disclosure, but we've done, or not me, but our team, our risk team has done, and the patient safety team are the ones who have done the analysis, and they've reached their conclusions. And we want them to know that we realize that they suffer too, and there's a whole aspect of this that goes to supporting the caregivers who have had a role in doing sort of the opposite of what their life's about, and they've hurt someone. And so we want them to understand that we recognize that, and we will apply things justly, and we will look at the system. So frequently when we reach out to a doctor, we say things like, okay, we're looking at this event, we know about this situation that happened, we'd really love your perspective. We really need to understand your view. We need to understand how our process has failed you and failed your patient. So, and that's sort of the approach we take. I don't know if it always feels that way or if they feel like we're looking at them, but we're trying, and it's all a little bit new, and we're working on developing that trust. So we have these rules, and I sent a couple of rules. You're probably familiar with them. There's 408 and 409, and then we have the apology statute, but to me they just all kind of come down to this. They come down to the same thing. So if you're expressing apology or sympathy or condolence or compassion or that kind of thing, your comments are inadmissible. You can also explain the sequence of events and the significance of those events, and you can make offers. And those things are inadmissible. Say we didn't resolve, and now we're in trial. These things can't be admitted to prove liability anyway. And then there's this legislative note, which, which sort of explains that they get the whole communication and resolution program. They want to encourage that kind of thing. They want to encourage disclosures. And I think in the case, this case, there's even a comment somewhere in the opinion that talks about full disclosure. So I don't know if you've all read this case, but this involved a young woman. She went to St. Mark's ER. She was having an allergic reaction to a medication she had taken, and they were treating her with epinephrine. So the order was to inject epinephrine sub-Q, which just means a little bubble, like when you get your TB test. It's just a little, just in the skin, really. But the nurse mistakenly administered it in a vein, so it had a much more intense and rapid effect than you would anticipate. And so, I don't know what that must have felt like. I imagine if a tiger ran in here, her body kind of did what we would all do if a roaring tiger was chasing us down. So probably pretty intensely uncomfortable. But the case, so they admitted, St. Mark's admitted liability. They stipulated that they had breached the standard of care, and the case was really, that went to trial, was really about causation. What did it cause her? So other than the intense discomfort and a couple of days of treatment in the hospital, she alleged a lot of long-term effects that the hospital disputed were related. So this, the trial court excluded a lot of the apologies and comments that the risk management and hospital administrators and doctors, all the statements they had made. And there was a defense verdict, but it was appealed. And these are the things, I focus pretty much on that aspect of the appeal. But the court looked at relevance since they had stipulated to, a breach of the standard of care. They really didn't need these comments to prove liability, so that was one thing they looked at. But the part that worried me was the characterization of the comments and statements and the analysis there. And I think it's true. I mean, I agree. It's completely supported by the legislative committees and their hearings and the statements that were made during that process. But I still don't know how you describe in any meaningful way the significance of events and the sequence of events, and you do a full disclosure without making some admission, right? You, at least of error. And then in the opinion, the way I read it, they focused a lot on admissions of fault, and then they kind of glossed over error, but ended up, it's the same thing. So it leaves me feeling a little like I'm on shaky ground when we're doing some of these disclosures, because we want to say, here was the error, and that's how transparent they are. This happened, then this happened, then this happened. This was a mistake. This should not have happened. She should not have gotten this medication by this route. I don't know how to do that without getting crosswise with the admissibility. So I think what we tell our team that's doing disclosures is, you might be making an admission. I don't know. I mean, we don't have a lot to go by, but you very well are making admissions. So as long as you realize that and you're willing to live with those admissions, do what you need to do to follow the process and make healthcare better. It gets really, really tricky when we're dealing with a situation where there were multiple players involved in this error, right? And especially if they're not our physicians. So we have what we call affiliated physicians, and we have system employed. So there's physicians that work in our hospital that are Intermountain employees. And then there's physicians that are privileged to work in a given hospital and perform certain procedures that are not our employees. We don't indemnify them. We don't provide them with coverage or defense. And they might be involved in one of these events, and so that's really tricky. And on those, we don't talk about fault, we don't talk about errors, we lay out the sequence of events, and maybe the significance to the extent you can do that without explaining what it caused. But for our own physicians, there's a lot more transparency, and it might be why this approach and these programs are getting adopted quickly by hospitals and health systems, but physicians and their insurers are really not jumping on the bandwagon. And they also, of course, have national practitioner data bank concerns that hospitals don't have. So that's kind of the end of my prepared summary. But I'm happy to take questions.
So do you do this program always with your physicians? Like, is that the go-to, or are there times where you don't? Like, and you decide to just do it the more traditional way?
We have a bunch of cases in the pipeline that have been litigated. So that's a little bit of a lost opportunity, other than the ones we deliberately review and decide we're going to redirect, like the one I described. We do it with all the events that are happening now. And then an NOI, so a notice of intent to bring a lawsuit in med-mal, typically, they can come pretty quickly, but typically it's a year to 18 months after an event. So we are getting all of those, and to the extent we can still gather the right amount of information, there's an attempt to do that anyway. So there's kind of different categories of cases. The oldest ones are kind of far down the path of the old way. The very brand new events all go through this process. And then the ones that aren't really a claim yet, but happened a year ago, we look at it and say, can we really do it justice? Can we do a thorough investigation a year now after the event? Can we get the information we need? Would it do any good? Would it help the patient to heal? Are they just sort of so mad and resentful and bitter with us now that they filed this lawsuit a year later that it's just, we're not gonna really accomplish much. Yes.
How do arbitration agreements fit into this? I don't know. I know there was like kind
Huge
of
controversy.
controversy of 2003, 2004. So I just, is it the exact same if there is an arbitration agreement?
Yeah. So yes, I mean the short answer is yes, but yeah, there was this period of time where Intermountain decided you will arbitrate patient, or you're not going to be our patient, sort of, which didn't last very long, thankfully, because so what we started to do in legal, and I joined a little bit after that. Kind of went through a couple of different approaches, was to say an arbitration agreement is just that. It's an agreement among parties that this is how they want to handle their dispute. So instead of saying you must sign an arbitration agreement, or oh, you signed an arbitration agreement, so you must arbitrate, we now say, do you still want to arbitrate? Maybe we're willing, if you insist, we will, because we signed the agreement, but if you don't want to, we can, we won't enforce that. So there's a lot of different opinions on whether an arbitration is the way to go in med-mal or a traditional court, and there's pros and cons of both. But we no longer demand and insist that since you signed that, however, long ago, you must follow that route. At least not like it used to be done. And then there's less and less because we no longer require them to be our patient.
But this new system would still be implemented regardless.
Yeah, so we actually had a patient who this makes me really nervous, but sometimes patients call the legal department and we're like, we can't talk to you. We help the other guy. It's like, we don't really do it like that, but it still makes us nervous, and we gently explain that we're probably not their best resource. But we had a patient that called and wanted to arbitrate. They had an arbitration agreement. They wanted to trigger their arbitration by calling the legal department. So we said, okay, but we want to know what happened to you, and we want to understand it, and we want to make sure it gets investigated. So that's fine. That you might need some help because there's ways to initiate the process, and we can't really give advice about that. But we would like to gather information from you and start investigating. And that patient, and probably most patients, are like, oh, well, I thought I had to demand something to get your attention, but if you just want to find out what happened, I'm happy to share it. And so she got routed into an investigation. Yes.
Hi, Carlos. Brielle here. Thank you for being here. That's interesting. I was wondering, I didn't really get when you started the new communication and resolution program. And depending on that, my follow-up question would be, was that as a response to 409 being put in statute in Utah? And do you envision a state or that type of program in a state that doesn't have that provision, or is that essential to have the new type of resolution and communication program?
So we started just about a year ago.
Okay,
So
after.
December of 2017, January of 2018. As far as a concerted, formal process, but what we started was, let's develop this process as we're doing this process, and so we're still learning, but those early months there was some misses where something got routed to outside counsel and just went off on a path because it fell through a gap. But as a concerted, intentional, deliberate adoption of early communication and resolution, it was just about a year ago. And I know the state laws vary. I love the states that include admissions of fault, but I feel I guess I'm conflicted about it a little bit. But if you had nothing, if you had like no apology statute, I think it would be a lot harder unless you had a really passionate believer in the benefits, because we're now getting studies. So the paper I sent was written in April or something of 2017, and it was like, the jury's still out on this. We don't know, maybe it'll make everything worse. Well, there was a recent study where a group of hospitals in the Boston area had tracked this for like 7 years, and they're showing savings in claim settlements, savings, of course, in defense fees, improvements in their system, improvements in patient safety. So those things are really promising and encouraging, but I think if you didn't have the comfort level of knowing you can at least sit down and have some types of conversations, and it can't be used then against you, it would be really hard to get the buy-in of the physicians. And with ours, you know, we don't want to wait, so we have like 10, I don't know, maybe 11 clinical risk managers throughout the system, so 22 hospitals. So they can't get to everybody instantly. So we want our physicians and our medical directors and our hospital administrators to go to the bedside when something happens and do the rapid response, and say we're sorry. But all they really have to say is we're sorry. Here's what we know happened, but we don't know why or how, and we're going to look into it. We're going to investigate. It's pretty easy to stay out of trouble with our protections that we have for that phase. It's when you learn more and you find out that there were some really bad mistakes made or some individual decisions made by caregivers and providers that really did cause a serious injury. That's when it gets harder to know how do you say that, and to know who in the organization decides that you're going to make an admission, knowing that you're probably making an admission that could be used against you. Who makes that decision? Those are things that we still are sort of working through. And then when it comes to an affiliated provider who may have a claim against us for making an admission on their behalf that then their insurer now has to defend, it just compounds the struggle. Yes?
I'm curious about how this process has affected medical malpractice insurance for doctors. Has there been more or less? Has it not affected
Like
it
the
at all?
premiums?
Yeah.
I don't think, I haven't seen anything that describes a tangible impact. I mean, you know, it certainly saves on defense costs. We're seeing that. So we're getting a lot of cases resolved that we used to send to outside attorneys, and they would be in discovery for 2 years, and we're resolving them in a couple of months. Just by being honest and candid and truly trying to identify what are we responsible for. And we're doing a lot of that in-house, so we're saving a lot on defense fees. Are our settlement values going up though? That's, you know, maybe. I mean, maybe without the benefit of years of chipping away at the theory of why they have all these problems and just being willing to not analyze everything to that degree and make sure you're saving so much money here on this claim and so much money on this alleged injury. Maybe the settlements are maybe we're not seeing a savings when it comes to the actual settlement award to a patient. It's really hard to know, and part of the reason why it's really hard to know is it takes years, and we're just starting to get baseline metrics. And the other reason it's really hard to know is really a positive, and that is we're not used to like looking at our settlement value in the year the claim came. So usually we have the claims come in and like 4 years later we know what we're paying out. But now we're sort of doubling up, right? We're paying on claims that came in 4 years ago, and we're paying on claims that came in a month ago. So it looks really high now. So it's going to take time for that to, you know, be meaningful data. Yes.
Any questions?
So my question is about the communication and resolution process, and forgive me if you touched on this and I didn't catch it. But what I was thinking about was how it begins, because I remember, so we talked for a moment about how healthcare providers need to feel comfortable to report. So does it always begin on the healthcare provider side, or are patients the one initiating it?
It could be patient.
So the thought that I had was more about incentives for physicians to report. I don't know much aside from what I've seen on TV, which is embarrassing, about the way that like medical careers go, but I suspect that there are adverse implications to reporting errors, whether that's for the doctor specifically or the healthcare provider specifically, or licensing issues. And so I guess my thought is, does this address that? Is there a way to address that, or are those adverse implications supposed to be happening, right? Like, maybe that's not a bad thing, right? And I just wonder what your thoughts were on that.
So, I mean, that's a super, you know, good observation. And so what you have to consider is the burden of the deny and defend approach. And it's real. I mean, physicians, you know, crack, they break down in tears, they throw up before their deposition. I mean, it's real. And so it alleviates that. It takes them out of sort of a hiding and carrying this to themselves, not talking to anyone but their attorney or their spouse, not looking at their medical records unless they're sitting with their attorney. All of this stuff that feels so sort of shameful and onerous and scary, and just, you know, hoping that their insurance carrier is going to make this go away, right? And not everybody, right? The physicians and the caregivers that are also really fun to defend are like, bring it on, right? I did everything great. And maybe they did. But I think for most caregivers who devote their lives to helping people, it's a huge burden. So, and then there's things built into the process to help them with that. We have a medical director who's a surgeon who reaches out to physicians as soon as they're named. We have people reaching out to nurses and whatever caregiver to let them know it's okay, we're going to look at it, we hope they'll help us with some learning, some good will come out of this, even if there was an error, even if it's their error, we try to help them see that they can be part of improving, which speaks to the people that go into medicine. But there's those real concerns, right? Will my premiums go up? Is this national data bank reportable? How's that going to affect my career? How's it going to affect my privileges? How widely is this information being shared? You know, what about Intermountain as a system and as my employer? What's their role in all of this? So yeah, and then reports to licensing agencies and that kind of thing. If there is a licensing issue found, yes. And I think that is a barrier to some degree. But what we want is the physicians and the caregivers who really want to embrace the just system, right? Let's root out ourselves who really shouldn't be here. Let's do that ourselves instead of protecting those people, because someday I might need protection. And let's be really fair about the innocent mistakes, the lapses in attention, the need for training, and the system processes. So I think the majority of the errors and the mistakes are really a system failure. And we work really hard to find those system failures. So nobody goes to work really thinking, oh, today I'm just really going to hurt someone. But the processes we have in place that we're responsible for as an organization set people up so that if it's not their best day or something is happening that's unexpected, they're just in the wrong place at the wrong time. And recognizing that and reaching out to those people and saying, we understand this and we're fixing our system. This isn't about you. This could have happened to anyone. And that's part of the whole, it happened here, meaning it could happen to you too. It could happen to anyone. So look at these factors and see if there's things in your work area that need to be fixed before it happens. Does that answer your question? I mean, the other thing that I didn't mention that's sort of along this topic is the affiliated physicians, right? They have UMIA or doctor's company or whatever, they have an insurance carrier. And insurance carriers aren't really set up to start making payments to someone while we investigate. But we are, and we do that. So we'll say, well, you really need like physical therapy and we're gonna pay for that. Go, you can go where you want, you can go where we recommend, whatever. But until we figure out what happened, we're gonna get you the care you need. We pay for people to stay near Primary Children's Hospital in a hotel. We pay for their gas money, all while we're investigating. And insurance carriers they don't have that mechanism in place, right? They are set up to hire an attorney and pay defense costs and to pay the ultimate settlement. They might have some money for what we call interim immediate needs, but it's not something that they really do very often, or it's a thing that seems really foreign to them. And when we try to get them to help with these things, it's very challenging. It's like pulling teeth. And so we end up doing it anyway sometimes, even though, as the investigation is revealing information, we find that it wasn't a failure in the system. It was really an individual failure, and maybe that physician is responsible for the injury, but they don't have a mechanism to help the patient in the meantime, so we just do it. So now, which is really foreign for a defense attorney, like it's really a good day when we did all the bad. It's like, oh, it's all our fault. Great, we can fix this. It's hard when it's like, oh, we're trying to be fair, we're trying to be accurate, we're being thorough, and it really looks like an individual, problem, maybe a repeated problem. It's harder because you have obligations to the organization not to just pay for everything that anyone does. Yes. Oh, sorry. Okay. I keep seeing you.
That's okay. Hi there, I'm Snail Brown, I'm a professor here, and ironically we just covered the Lawrence case in my evidence class today.
Really?
An hour, yeah.
Do you have the answer to my question?
Well, so I think you're exactly right that it doesn't provide much protection. It makes me actually wonder whether it's worthwhile to even reference 409 to physicians to give them some sense of safety, because it's false safety. And it actually does the exact opposite of what the policy behind a rule like that is meant to foster. Because it doesn't get in apologies, which I would think would actually make the physician look more sympathetic. I think most people can understand that apology doesn't concede guilt. Like there's a more sophisticated view of apology, that you can be sorry something happened to someone without acknowledging any breach. So the fact that the breach can come in and the apology can't actually is the exactly wrong outcome, I think. So my question is whether you think it's even worthwhile to reference that rule to give some false sense of security to physicians that they don't have. My second question is about nursing staff, and I've served on some dissertation committees for nurses looking at systemic error and how they feel that a lot of the emphasis is on making sure physicians their egos are protected and that their jobs are safe, because they're more safe, but there are just different concerns when you're talking about nursing disclosure of errors, and the fact that they're more likely to make the errors, especially at shift change, but they're overstaffed and less protected. So you can answer either, both.
So I'm going back to the first slide, which is because I struggled with the name. But to answer your last question first, there's a huge cultural issue, right? The nurses feeling responsible to be protective of the team, protective of physicians.
But also not safe. They don't feel as safe.
Feeling intimidated, feeling like the leaders value the physicians more than the nurses, feeling afraid to speak up, and that's a big, it's a big part of the problem, and a lot of problems sort of stem from that culture, and it's so ingrained in healthcare. But and it's going to take a long time. But what we're learning as we apply this approach is that there's the team that supports the caregivers and reaches out to everyone involved. So say there was a mishap in the OR and the nursing staff, you'll find that nurses and other non-physician healthcare workers they don't quite share when they're doing their event report or when something first happens. But when the team goes in to support them and really focus on, the purpose of what we're doing, sometimes it just all spills out. And they ask, well, why didn't you say that like last week or a month ago or when it happened? And I think it's that feeling that they're not as valued, they're not going to be protected. They get safety in protecting the powerful people. So I don't know how to overcome it other than keep applying this system and really listening and really supporting them and getting their perspective in a safe environment, which those meetings are, which sort of goes to your next question. So we also enjoy quality improvement protections under Utah law. That's another area where as we move into resolution and we're dealing with attorneys, sometimes plaintiffs' attorneys, and we want to share enough to get what we need to get done, but we don't want to waive, a conversation or an interview or something that was protected under peer review mostly because the value in that process is everybody knowing that that's protected and it won't come out to hurt usually someone else is what they're worried about. Well, if I give you this interview and I tell you what really happened in that OR, you're promising me that I'll never see the light of day beyond what you're, this improvement you're going to make and the people that really need to know. So waiving that isn't so much, in a given case, if we waive it, we could be ending up admitting and introducing into evidence a lot of really damaging information. That's a small problem compared to losing the confidence in the process and the reliance on the confidentiality of those meetings. And, 409, I think it helps us on the initial rapid response conversation because really we don't know anything and we do counsel our physicians. You don't want to start talking about causation or what led to what, because what seems obvious to you frequently turns out to be completely erroneous. So you want to wait for the investigation so that you really know what we did and what led to what. So it gives them the courage to go into the patient's room and say, this just happened. This wasn't intentional. We don't know yet how this is going to impact you. Those kinds of conversations. But we will look and we will share it. We will find out, and you'll be part of that. So it gets them through that, and then the disclosure. is really a very deliberate process. There's a plan that's written out, so there's a document that's prepared with the physician. The physician has the option of being present for the disclosure, or the patient safety and clinical risk team might do it with their medical director if they need that, level of medical knowledge and expertise to answer questions. But no, I think that we go into those disclosures realizing that our goal is to resolve, and we'll avoid admissibility by never going to trial and not litigating. But there's no guarantee there. So I don't think we go that far. It gives them courage and reassurance to talk to their patient right away, so that we don't start developing the resentment and those feelings of the patient. That's about as far as it gets us. I think you're right.
Thanks.
Yes.
Okay. Thanks. I'm George Contreras, and I teach here as well. So I'm curious. So the narrative that I'm hearing behind this approach to communication is really, and it's one of improving the healthcare system, sort of ethical obligations that medical providers have. But I'm curious what the economic narrative is. So doing things like paying for people to stay in hotels before there's liability, making damaging admissions to plaintiff's counsel, before. And those have a price tag associated with them. And I guess my question is what, and clearly somebody at Intermountain has said, what is this costing us and should we do it?
Right.
And what is the answer? And there are several different answers that I'm speculating about as I sit here. One is, well, yes, it's going to cost us another $5.2 million a year to be good guys, and that's our ethical obligation. Or another answer is it's not going to cost us anything because it's going to buy us additional goodwill with potential plaintiffs who are going to drop their suits or settle their suits. You hear this, people sue because they're angry, and once they're not angry, they stop suing. So what is it, just for obviously I don't need to know for Intermountain specifically, but for a big HMO or healthcare provider, what is the economic calculus behind this?
Well, so for us, it's going to save us money. So that's the argument, that's the theory. Whether that turns out to be true is yet to be seen. But the theory is, it really is also, in addition to the right thing to do and a long-term improvement of just the healthcare delivery, it's a cost-saving measure on claims. So the typical med mal claim for us is a 3 years, I'd say, is average. Some are super long, like 10 years, and some are relatively short, but I think 3 years is really common, and that's a lot of defense costs. It's a lot of, there's a lot of discovery, and over 95% of our cases settle anyway. So we look at cases and see that we probably knew the value in the first, couple months, but it took us 5 years to get it resolved. So we've paid what we would have paid, plus all the defense costs. And then another, and that's just the typical landscape in Utah for med mal defense. But we're already seeing evidence, I think, and signs that our theory, which is in the long run, this will also be a cost saver for the organization, that might be true. So we are starting to get calls from plaintiffs' attorneys. I get calls from plaintiffs' attorneys and emails, and they go, I have this client in your hospital. why don't you take a look at this? Let me know if it's something you want to maybe resolve outside of litigation. Gives me weeks to review, to get an analysis done. So this is another input, right? Something bad happened. We're finding out something bad happened because they're talking to an attorney who's developed a level of trust that we're going to be fair. So, and then they save, right? If they don't have to charge, if they don't have to hire experts, as many experts, if they don't have to spend a lot of time on discovery to get answers. So they sometimes ask basic questions. There's a little bit of give and take, like, are these your doctors or are they affiliated?
Right. Well, so it occurs to me that the plaintiff's bar would love this program, right? I mean, the med-mal plaintiff's bar are your best friends in this program because they fund the litigation themselves for that 3 to 5 years, right? They're not being paid by a big corporate client who pays them an hourly rate. They're taking 40, 50% of the take, which they can get, if they could get that in 2 months, that would be, that's the jackpot for them. So is there resistance from the defense bar? And those would be the ones who, your lawyers.
Yes, there is. There is, and some are starting to understand, but it doesn't come naturally or easily to our defense attorneys. And they do, I think, feel a little uneasy that we're developing relationships. And it's a little strange, it feels a little strange at first to us too, that we're, I've always had a lot of respect for plaintiffs' attorneys, and I've had good friends that have worked on both sides of the bar. And you know who's difficult, and you know who's reasonable, and who's going to be straight with you, and who's going to hide the ball with you. But it's still, it became evident pretty early on that we need to get word out to the plaintiffs' attorneys. And we didn't do it in a really concerted or deliberate way, but they're very well connected. They're much more connected than the defense bar. They share a lot of information about their cases with each other. And so it didn't take long for some of these early resolution, and especially a very well-known attorney who was a very, takes high-value cases, was at that disclosure meeting and was pretty much blown away and shared that with us. It doesn't take long for the word to get out. Now, not everybody's happy. We have plaintiffs' attorneys who feel like they have this slam dunk case, and they're very disappointed when we say, this is a known complication of the surgery. There was no error. We're going to defend good care. And that's the other thing that helps our docs. And that's another difference that we'll probably see as this moves forward, is we didn't do a good job of either, really. We didn't do a really good job of standing up and going to trial and defending good care. We would fight, and argue and bicker and have motion practice, sometimes meaningless motions, and waste money and waste everyone's time, and frustrate the patient, who's now a plaintiff, and then settle. Because it really wasn't, strong enough to go to trial, or the costs of trial, and the cost in time and money of going through a trial just didn't make sense. But the flip side of this process is good medicine will be defended, and we'll have more trials, but there'll be cases that we really feel strongly about our care, and we want to support the caregivers in that way. And hopefully over time we'll have less mistakes, less patient harm due to medical error, and more opportunities to confront accusations that just have no merit. They're there, and we're starting to see those, more aggressive. We revisit it, make sure we're on the right path as new information gets revealed during discovery. So there's a loop back now that didn't used to exist, where an expert report that's particularly strikes a chord or makes a lot of sense, and that's very critical of us, will get sent back to the clinical risk team and the patient safety team. And if they feel like, hey, we didn't notice this at first, but I think they have a point, I think we have a gap here in our care, we might take a different approach to a case. I mean, obviously experts are, it's hard to be completely unbiased, no matter which side you're on, but some are very cogent and well-supported opinions, and we'll look at those and listen to those. Yes.
Is there a relationship between the FDA and healthcare systems, and does the FDA play a role in communication and resolution in the process?
So usually when we're looking at the FDA, there's a piece of a claim that involves a medication or a device, and we look for any indication that we should have been on notice and taken a different approach as a delivery system with respect to that device. So we have a pretty, well, I shouldn't say pretty, we have a very robust and reliable system to deal with recalls. But we always check and make sure we didn't miss a recall or, give a medication that was contraindicated or something like that in a given situation. That's more common than an actual recall. But I don't, and then there's a reporting database that anyone who's experienced a problem with an FDA approved device or substance can go in and report. So we look for those. Have there been others with these problems? But I don't think we, other than saying, hey, we saw this, we noticed this, I don't think we push very hard or really expect much of the FDA. If we have a bad outcome and we notice it's connected to a device, we let them know, especially if we think there's a defect of some kind. But it's more like just letting you know, you do something about this, figure it out, kind of a relationship. Did that answer your question?
Thank you.
Stick around for a while, there's food.
Food is always good.
Yes.
All right, I'm gonna try to do this by myself.
Probably I've never seen the favor of getting state lands out of the.
Yes.
Thank you for today.
Oh, no, I didn't.